My name is Chad Collin, and I'm a business lawyer and a shareholder at a law firm called Morella and Associates, located in the North Hills of Pittsburgh, PA, where I practice law in our firm's corporate commercial practice group and its litigation practice group. If you've made it this far in my series of videos about the business litigation process, you're about to learn about what is often the longest, most annoying, and most expensive part of a lawsuit: discovery. Discovery is the process by which the parties to a lawsuit exchange information about the factual background giving rise to their dispute. In Pennsylvania state court, this is primarily done by one side asking the other side to answer questions and produce certain materials. In federal court, each party has affirmative duties to disclose certain information without even being asked. Discovery is mostly done through requests from one side to the other side. There is written discovery, often called interrogatories, which are a list of questions that one side asks the other side about their version of the facts and the evidence. There are also requests for production of documents and things, which is where a party gets to ask another party to give copies of documents, writings, and other data and records. Then there are depositions, which is where one party's lawyers get to interview the opposing party or a witness for hours and hours and hours at a time. The interview is transcribed by a court reporter who puts the witness under oath so that he or she is sworn to tell the truth. The interview is also oftentimes video recorded. Parties are also entitled to collect discovery from persons and entities who are not litigants in the case. In other words, if the lawsuit is Company A versus Company B, but Company C has relevant information about the case, then Company C can be subpoenaed to provide testimony or documents. Importantly, discovery rights are extremely broad. A party is entitled to discovery from the other party on any information or documents that are reasonably likely to lead to the disclosure of relevant evidence. This means that the parties can cast very wide nets in trying to get information. And the grounds to object to a discovery request or refuse to produce the requested information are very limited. Privileged communications and information, such as correspondence between a lawyer and a client or between spouses, are protected from discovery. Very little else is. It is very difficult for a party to successfully argue that a discovery request is overbroad or irrelevant. In general, when such objections are brought before a judge, the judge will often err on allowing more broader discovery as opposed to less narrower discovery. Since the 2000s and the age of email and texting, a new type of discovery has emerged: e-discovery. This is where the parties have to turn over any text messages, emails, and other electronic files that they may have that may be relevant to the case. There are actually companies who specialize in assisting litigation attorneys with e-discovery, and what they do is they collect all electronic data from certain identified custodians, which are usually just important people or witnesses in the case. And they collect it all: emails, texts, Word files, PDFs, Excels. Then the parties to the lawsuit negotiate on search terms to run on this data. Say, for a convenient example, it was a case about a contract that went bad, and the contract had some sort of identification number that the company used to keep track of it in its business operations and files. Almost certainly, that ID number would be a search term. So would the names and email addresses of all the relevant witnesses, along with any other relevant words that are important to the case. After those searches are run, the e-discovery company packages it all up and delivers that culled data and documents to the other side. Oftentimes, this could be tens of thousands of pages of material. Then, the other side's lawyers get to go through all of it and try to find documents or statements that help their position. As you could probably tell, this process is extremely time-consuming and resource-intensive. It costs money. It requires the attention of your staff to review and collect relevant materials. It is invasive because it lifts the lid on pretty much every email you've sent or received in the recent past. It's not fun for anybody. In some situations, it can be a useful tool to getting the parties to settle their dispute amicably. Many times I have heard urban legends from other lawyers about some judges who, at the beginning of the discovery process, bring the parties into the chambers. The judge has a basket on his desk, and he says to the parties, "Have you ever sent or received a text or an email about this case using your mobile phone?" Of course, the answer is always yes. So then the judge says, "Okay then, each of you put your phones into this basket. The e-discovery support firm will be here in 10 minutes to download all the data off of your phone. Or we can use the next 10 minutes to negotiate a settlement of this case." And of course, as the legend goes, the case is always resolved before the data collection guy gets to the courthouse. By the way, in another video of mine, I talk about writing business emails and text messages under the assumption that someone else, like a judge or a jury, is someday going to see it. This is why. It's because if the deal or the transaction ever ends up in court, chances are that someone else is going to see it. I once handled a case where a member of the opposing party's staff wrote in an email that he didn't trust his colleague to babysit his cat, much less perform a project for a customer in a competent manner. Needless to say, that was very helpful to my client's case. Going through discovery is a real bear, to say the least. It's where a huge percentage of legal fees are generated. It takes months to years to complete. It is the part of the case that, in my experience, is the most frustrating for clients. So when a business comes to me and says they want to file a lawsuit, I always make sure to explain this process to them before we file the case. That's my video on discovery and litigation. I hope it was illuminating for you. I'm Chad Collin, business lawyer and shareholder at Morella & Associates in the North Hills of Pittsburgh, PA. Thanks for watching.